May I seek your lordship indulgence? I have a hearing list, item number 4.
Yes.
This is a civil matter. This may be taken up next week. I have a fixed item in the other court.
Other side?
Other side, okay.
No objection, madam.
All right. Prayer of learned counsel for appellant and with consent of other side list the matter after 1 week.
Your Lordship, similar prayer in item 7. If this can come up after a week,
Part 2 list.
part 2 list.
All right, same order.
I have taken the consent of the respondent.
For motion, item number 1.
My lords, item 1 is a contempt petition, civil contempt petition. My lords, the order was passed by this honorable court directing, my lords, the PWD to release retention monies subject to the outcome of our arbitration proceeding. Now, my lords, that arbitral award has also come, and my lords, the concerned officer, they have not releasing that particular amount. Even the arbitral award had, my lords, recorded the proceedings that had taken place before this honorable court, my lords. It was a direct direction that you release post the outcome of the arbitration award. Now that retention money, my lords, the project is complete. That only remains. But I must fairly state, my lords, what the other side has done is that on 15th September, they had filed an IA for modification of that order passed by this court. There, my lords, they had sought a specific direction that interim relief that, my lords, no contempt proceedings may be, my lords, contempt proceedings may not be pressed. But, my lords, the learned single judge of this honorable court, my lords, they had rejected that particular prayer also. I have the order. Notice was issued. In the meantime, my lords, we preferred this petition, my lords.
Where is that order?
My lords, I have it. We've mentioned it, but I have not annexed. If I may pass this.
Item number given. 30.
So this is only notice.
Yes, my lords. No, I just wanted your lordships to, my lords, be aware of this, my lords, so that there is nothing, we are not hiding anything, my lords.
What is the other arbitration that you have instituted? Is it connected to the same work?
My lords, it is connected, but I'll clarify that point, my lords. The award which we are concerned with right now, my lords, was passed in May of 2025. Thereafter, my lords, I have preferred an arbitration directly against the PWD, which was instituted sometime in, my lords, August. So, my lords, that is a separate claim altogether, because in the counter affidavit filed in the before the learned single bench, in the earlier round, my lords, the employer, which is the PWD themselves, had said that the issue is with regard to the proportion. We will pay. In fact, they've released 75% of that amount to the other party, subcontractor, my lords. We are the main contractor, my lords. This was also raised in that particular modification application, my lords, saying that since they have instituted this arbitration, but my lords, learned single judge had also observed that that is a separate proceeding altogether. And we're quite confident, my lords, that application is frivolous, my lords.
All right, we'll issue notice in this one.
My
Let them answer then.
Yes, sir.
Excuse me. All right, hard learned counsel. Issue notice. This is an application under section so and so of the Contents of Court Act, graduate. See the cost tag. For violation of judgment and order dated so and so, issue notice to the respondents. Petitioner to take steps by registered post with AD within 3 days, list after 6 weeks.
Obligement.
Formation, item 2.
Please, Your Lordship, this case, the respondent has not yet filed a reply affidavit, so-called reply, till date.
Your Lordship, I have received the instructions from the concerned department. If I may be given just another week time to file the same.
All right. So and so learned counsel appearing for respondents.
For all the respondents.
1 to 5 submits that instructions have been received from the concerned department and prays for 1 week's time to file the counter. Prayer is allowed list again after 4 weeks. 1 week.
Item 3.
Yes. May I please, Your Lordship, this is an application for modification or relaxation of bail bonds and sureties imposed by the Special Court and DNPS Act, ISOL, on the petitioners.
What is the modification required?
The bail condition imposed by the learned special judge is at page number 12 of my petition. That the bail bond of rupees 3 lakhs with two sureties who shall execute the same amount of bond. And number 2, one surety shall be a permanent resident of ISOL living in his or her own house, while one surety shall be a permanent government servant not below the rank of LDC. The difficulty we are facing is one surety who shall be a permanent government servant not below the rank of LDC, and the bail bond, amount of bail bond rupees 3 lakhs. We are the driver and co-drivers, so it is difficult for us to find the sureties.
Where are you from?
I am from Kachar, Assam. Yes.
Which state are you from?
Assam Kachar district.
Huh?
Assam Kachar district.
Assam,
Yes.
Kachar.
Yes, Kachar district. So it is difficult for them to find a permanent government servant not below the rank of LDC.
Look at your address. resident of Karka Basti, Kachar.
Yes.
Where is this Karka Basti in the whole district of Kachar? Is it a village? Is it a town? Any PO? Any police station? Nothing. Even if we issue an NBWA in a subsequent date, where will the police go looking for them? Same with the second one, Nandirgram, Kachar. Just the name of a place in a whole district.
Yes. May I please, Your Lordship? A
Yes.
similar order has been passed by the coordinate bench of this. A similar order, an order has been passed by the coordinate bench of this court in a similar situation upon the conditions, on the same conditions imposed by the special judge. May I submit that order?
First you submit full address with proof of address, and then only then we'll consider. Heard learned counsel for the petitioner. On perusal of the instant petition, it appears that inadequate address of the petitioner, both the petitioners have been mentioned. This court considers it fit to direct the petitioners to submit full particulars of their addresses along with proof in the form of Aadhaar card, etc. before entertaining this application further. When will you submit? When will you submit the address, full address along with documents?
This week, my Lord.
Okay. Friday?
Friday, sir. Yes, Friday.
Okay. List again on Friday.
Item 4.
Your Lordship, we have filed an affidavit incorporating the steps taken upon respondent number 2, 3, and 4 by way of Dusty.
And for the respondent number 1, my Lord, claimant.
When did you file the affidavit?
On 20, on the last week of August, my Lord.
Last week of August?
28 August.
That is on behalf of respondents 2 and 3.
2, 3, and 4, my Lord.
They have appeared after that. Yes, 2 and 3 has appeared. You are for whom?
Sir, there is an engaged counsel in the court list.
Okay, anyway, as per office note 2 and 3 has appeared. Lalram Ruata. Okay.
And my Lord, we cannot ascertain the correct address of the respondent number 4.
On 4 you have not filed the affidavit.
We have filed, but we did not serve them personally because we could not find their address. We've mentioned in the affidavit as well, my Lord.
You cannot find their address. Who are they?
He's the driver of the accident, the scooter.
4 is the driver.
Yes, my lord. The driver of the scooter boarded by the deceased.
No, in case you have not been able to effect justice service, then you have to file application for the next step, whatever is to be done. Paper publication or what?
Yes, my lord. Newspaper application.
For that you have to submit application.
All right, my lord. We'll submit.
All right. Had learned counsel for the petitioner, it is submitted that justice service on respondent number 2 could not be effected as the exact address could not be found. It is submitted
Respondent 4, my
that
lord.
appropriate application will be filed for effecting service on the respondent number 4. Hence, release the matter after 2 weeks.
Yes, my lord.
Item 5.
Your Worship, in this matter, the state is yet to file the affidavit. Respondent number 3.
What about the others?
They have filed, Your Worship. 1 and 2 have filed.
Who is it? Who is 3?
Your Worship, the Industries Department.
Industries.
Industries Department. Commerce and Industries Department. In fact, Your Worship,
So this was supposed to be the last chance.
yes.
What is the matter about?
Your Worship, this is regarding non-payment of family pension.
Okay.
And this matter was filed in March, Your Worship.
Who is supposed to pay?
Your Worship, in fact, the funding is by the respondent number 3. And it has to be paid through the respondent 1 and 2.
Petitioner retired from which department?
It's a corporation, Your Worship.
Okay. Board.
Yeah, both.
So what is the stand taken by the board?
Board is, Your Worship, they do not have money. It has to be, they have to sort of get funding from the state. They do not have enough money. That is the main excuse made by the board.
No money for pension?
Yes. They have, Your Worship, they had this pension scheme
Oh.
of 2002, which was amended in 2019. And according to the 2000 amendment, the pension scheme was amended, whereby our pensions were stopped. We challenged the amendment, and the amendment was struck down by the Honorable Division Bench. So now we are back to the original scheme of 2002, and we are supposed to be paid our pension according to the 2002 scheme. But till date, they have not paid us for quite some time now. So that is why now the KVI has taken the plea that since it has to be funded by the respondent number 3, they don't have the funds, required funds. In fact, respondent number 3, the additional AGs are here. I'm sure they can get instructions.
If I may, my lord.
Commissioner and Secretary, Commerce and Industries Department.
Yes, my lord. On behalf of the government, my lord, the matter is being handled by Ms. Lalnu Lui. She's on leg in the other courtroom. And if this matter can be passed over for the time being, my lord. She might have some instructions, my lord.
All right. Let the com-
Otherwise, Your Worship, there's an analogous matter. This can, in fact, both these matters were initially clubbed together, but I don't know, somehow the other connected matter was listed last week, and this matter has come up only today. So this is the last order in the connected matter. Your Worship, that matters regarding payment of pension to the pensioners. The present matter is related to payment of family pension. But the question involved is the same, payment of pension, family pension and pension. So if this matter can also be listed on the second week of November. There are two writ petitions. One is filed by pensioners, one is filed by persons who are getting family pension. So that is, Your Worship, filed by the pensioners. So it can be listed together, Your Worship.
All right. Then, in the meantime, if you like, you can make finance a party.
And Your Worship, let them file the affidavit and at least give a reason why they feel that finance department is necessary party. Without the affidavit, Your Worship, just by making verbal submission that finance department is a necessary party, I mean, let them file the affidavit and explain why finance department is required to be implemented. Then, if required, we can always do that, Your Worship. But without the affidavit, just making a verbal submission.
That would only amount to giving them another chance. That is all.
Anyway, we'll do it. By the next court date, we'll do it here.
Huh?
By the next court date, we'll implement the finance department also. Let the matters come up together here.
All right. Hard learned counsel for the petitioner and learned counsel appearing for
Respondent 1 and 2, my lord.
respondents 1 and 2. Respondent number 3 is yet to submit its affidavit despite being granted number of opportunities. It is informed that an analogous matter being WPC 22 of 25 is pending, wherein by order dated 26/9/25 the matter has been directed to be listed in the second week of November. Full stop. It is also noted therein that the learned government advocate appearing for respondent number 3 had submitted that she had received verbal instruction that a consolidated affidavit has to be filed, since the issue would also require the finance department to answer the claims made in the writ petition. However, finance department has not been arrayed as a party in either of the cases full stop. Para learned counsel for the petitioner submits that the present matter be tagged with WPC 22 of 25 and listed together for the second week of November 2025. Hence, tag this case along with WPC 22 of 25 and list the same on the second week of November. Full stop. In the meantime, the concerned respondent may file its affidavit.
Home obliged.
Items 6 to 22.
May it please your Lordship, as per the communication made between the parties, this matter may not be feasible for mediation. So if this matter may be fixed for admission hearing at the end of November, and during that time, all the pleadings so required may be filed by the parties.
My lord, as per the last court order, I was directed to obtain instruction as to whether the MORTH can give a consent for mediation or not. But due to new incumbent of the officer concerned, I seek 1 week time for obtaining instruction.
You are saying it's not fit for mediation?
Yes, my lord, because the question involved will not be feasible for mediation.
Okay, if one party does not agree, then there is
Yes.
no question of.
All the petitioners not agree.
Hmm?
All the petitioners in the other similar matter, we are not agreed to mediation.
You are not?
We are not agreed to mediation.
Not agreed.
No,
Okay.
because it's not possible. We are challenging the
Heard learned
notification.
counsel for the petitioner and also learned counsel appearing for the respondents. It is submitted on behalf of the petitioner that the instant dispute is not capable of being resolved through mediation. And prayer has been made to list the matter for admission in the month of November.
20th November, my lord.
Accordingly, list again on 20th of November. Counters have been filed.
Counters have been filed in some matters, but it's all the same matter, so necessary pleadings may be completed by then, my lord, by the 20th November. Because it will also
In the meantime, counters on behalf of the respondents who are yet to file the same may be filed.
Obliged, my lord.
Item 23.
Yes, 23.
Your Lordship, this is a jail appeal. And it has come up for the first time. Notice has to be issued.
Any defense counsel has been appointed. The accused has requested for legal aid counsel.
Yes.
This is a jail appeal preferred by the appellant. Nathan R. Kobung. Prayer has been made for appointment of legal aid counsel. Accordingly, so and so is appointed as legal aid counsel to represent the appellant. Issue notice. Copies of the petition be served upon learned public prosecutor and also upon learned legal aid counsel. List again on
Your Lordship, a trial court record may be called for. A trial court record may be called for.
yes on so and so. Also call for the TCR. Okay.
Item 24.
Your Lordship, in this, we are yet to receive comments on from the concerned departments. So may I seek another 3 weeks' time for filing affidavit in opposition? Oh, I'm sorry, Your Lordship. I thought it's item number 25.
Respondent 3 and 4.
Yes, Your Lordship. I am hearing for the respondent 3 and 4, Your Lordship, and I am yet to receive any instructions in that regard as to whether they will be filing an appeal, Your Lordship, an affidavit. The state has already filed, Your Lordship.
One and two has submitted.
1 and 2.
Yes, Your Lordship. I'm yet to receive any. I've sought for the pairwise comments from the respondent number 3 and 4. However, Your Lordship, I have not yet received any instructions. So I'll be, if I may be allowed 2 more weeks, Your Lordship, to get the final instructions.
All right. Heard learned counsel for petitioner. Learned counsel for respondent number 3 and 4 has submitted that instructions are yet to be received and prays for further 2 weeks' time. Accordingly, list the matter again after 2 weeks.
Much obliged, Your Lordship.
Item 25.
Your Lordship, my sincere apologies for mistaking the item. In this item, Your Lordship, may I seek 3 weeks' time for filing affidavit in opposition?
The instructions not yet received.
Not yet received, Your Lordship.
Same order, okay. So instructions are yet to be received and place for next time. List again after 2 weeks.
Duly obliged.
Item 26.
May it please Your Lordship, although in the last order it is noted that the AD card for respondent number 5 is not returned, Your Lordship, I have received instructions that I'll be representing respondent number 5 in this matter, Your Lordship. Kala.
Heard learned counsel for a petitioner, Ms. So-and-so, enters appearance on behalf of respondent number 5 and submits that counter affidavit will be submitted within?
Your Lordship, if 3 weeks time will be granted, Your Lordship.
Within 3 weeks. What about the others?
Malabar for respondent number 1 and 2, similar prayer.
Similar prayer is made on behalf of respondents number 1 and 2. Hence list the matter again after 3 weeks.
Item 27.
Lordship, as per the office noting, tracking was done by the registry, and it appears that respondents 6, 7, 9 and 13 have been served. And respondents 8, 11 and 17, there is no definite finding regarding whether they have been served or not.
So even as per the tracking report, it is not complete upon 8, 11 and 17. As per office note, service is not yet complete on respondents 8, 11 and 17 as per tracking consignment note. Full stop. Hence, list again after 3 weeks.
Affidavits have been state.
Yes, Your Lordship, we have not yet received instructions in this regard, so if 3 weeks time may be granted, Your Lordship, to file the affidavit of opposition on behalf
Alright,
of
this will cover it. Okay.
For orders, item 28.
May it please Your Lordship. My Lord, it appears from the office note that TCR, scanned copies of the TCR and the case diary have not been received back. So if this matter may be listed next week, perhaps Tuesday, or any other date convenient for the registry.
Scan copy of TCR along with CDS call for has not been received. Issue reminder, list again on?
Next week, Tuesday, my Lord. 21.
All right, 21.
Deeply obliged.
Item 29.
Please, Your Lordship, my senior is having some personal difficulties. Can this matter be listed after 3 weeks?
Nobody is appearing for 1 and 2.
Lordship, no one is appearing. Though its notice upon them are already completed. And I've
What
already
is the IA? IA is for what?
IA is for the continuation of the delay. There is a delay of 220 days in filing the connected matter appeal.
What's 420 days?
220, 220. Lordship, that respondents number 1 and 2 were represented before the learned tribunal. I've already spoken to their advocate before the learned tribunal. So I don't know whether they are going to represent it here again or not. I'm not sure.
Yes, somebody is appearing. What is the awarded amount?
So the total is 6,50,000. Lordship. This is under 163A of the MV Act. Also, there was a statutory defect in the insurance policy. This is the private car, and the insurance policy was the act-only policy. So unnamed passengers was not covered. That was the main ground of the insurance company.
Yes, have you submitted any counter?
Yes, we have already submitted our written objection.
Huh?
We have already submitted our written objection on behalf of respondent number 3.
Who is appearing? Anybody appearing to VC? Somebody is appearing. Somebody is appearing to VC in this case. Next. Okay. Yes, what do you have to say?
My lord, my senior is having some personal difficulties, so he cannot appear today. So can this matter be listed after 3 weeks?
That is the first thing you should have said after going through all
already
of this.
mentioned.
All right. But after 3 weeks. On the prayer of
Lordship, may I? Lordship, there is an analogous case in this matter. So that is make appeal number 6 of 2025. It may be clubbed together, Lordship, when the matter is listed.
Our learned counsel for the petitioner, it is submitted that there is an analogous matter being number
6 of 2025. Make appeal number 6 of 2025.
and that this matter may be tagged along with the same. Prayer is allowed. List this matter along with so and so. When is that one fixed?
Also, it says that after 3 weeks, because his senior is in hospital.
After 3 weeks, okay.
A pleasure.
Item 30.
May I please, Your Lordship? May I please, Your Lordship?
Yes.
Lordship, it's a criminal appeal, Lordship. Here in this case, as reflected in the cause list, TCR already received, Lordship. Registry may be directed to prepare the paper book, Lordship. And there is a IA also for suspension of sentence, Lordship. No objection is till date filed by the prosecution side, Lordship.
Your Lordship, I would like to make a prayer with regards to the IA. Since the TCR has already been received, let the paper book be prepared and matter be heard on merits. Priority can be given, Your Lordship.
What is the sentence?
It's
Sentence of 10 years, Lordship. Page 30, Lordship, in IA, Lordship. Sorry. Sentence part is page 26, Lordship.
There is commercial quantity, isn't it?
Yes.
So minimum
But there is a-
sentence has been imposed. Criminal appeal 27 of 25.
But conviction is only given on the basis of assumption, Lordship. Whole prosecution witness were examined, 2 were discarded, Lordship. By
Okay,
the court
let the
itself.
paper book come, then we'll consider.
Yes, Lordship.
Copy of TCR has been received. Registry is directed to prepare the paper book. And thereafter list the matter for admission. Is it? This is for admitted. Yeah.
appeal was already admitted on
Admitted
16/9.
for hearing. Okay. Hearing. For hearing. In the IA, you write the prayer for suspension of sentence shall be considered after preparation of paper book. Okay. List after paper book is ready.
May I pray for accommodation at fixed rate, Lordship? As per Lordship, convenient, Lordship.
Okay, instead of saying paper book is again, list again on, give a date after 1 month. Okay.
Highly obliged.
Item 31.
Please, Your Lordship. My Lord, this IA is for condonation of a delay, my Lord, in filing the connected MAC appeal. There's a delay of, my Lord, 153 days, my Lord.
Your Lordship, I will file my objection today, ma'am. For I represent respondent number 1, ma'am.
Learned counsel appearing for the respondent number 1 submits that the affidavit in this, that objection against the IA will be submitted during the course of the day. Prayer is allowed to list the matter again. On? What, next week? Next week.
Oblige.
Item 32.
Lordship, we have filed an application for modification of the order dated 14/8/2025, wherein this Honorable Court has passed an interim order which has affected the rights of the applicants, Lordship. The order is at page number 17. Page number
Before
68.
that, who are respondents 6 to 17 were supposed to file affidavit?
They have engaged a counsel.
I believe Mr. Joseph was engaged as a counsel for respondent, the private respondents.
As per the cause list, Your Worship, Mr. Joseph Rentley is there, engaged counsel.
Oh, the main petition.
The main petitioner of the state also has to receive some of that.
But you are on their side, isn't it? You want to file office? You are on the same side, aren't you?
Your Worship, frankly, with the miscellaneous application filed by the respondents 18 and 19, newly pleaded, Your Worship, even in the prayer, we have no grievance against them because they are not engineers. They are graduates having that 1-year course. So we have no grievance against them being appointed. Our grievance is only against the private respondents 6 to 17, who are basically engineers and who do not have that essential qualification of 1-year survey course.
But 6 to 17 may have an objection against their prayer.
No, Lordship, I believe they have prayed for that affidavit in the last vote. They have prayed for affidavit in the main petition. In the main petition, not in the IA.
Let this matter come up on Thursday. We'll inform the council for the respondents 6 to 17.
Okay, on the prayer of learned counsel for the parties, list the matter again on Thursday.
This junior was here, but I don't know.
Item 33.
Lord, in this case, the counsel for the petitioner has informed me that he has some personal difficulties. He had to visit his ailing brother in another district, so he has requested me to pray time on his behalf.
One to 5 you are appearing.
My Lord?
1 to 5 you are appearing.
1 to 5, my Lord. Yes, my Lord. All the opposite party respondents, my Lord. I'm for all the respondents, my Lord. 1 to 5. Say.
So are you filing any objection?
My Lord, I have to look into the case, my Lord. I might file, my Lord, in the meanwhile.
Delay is only of 31 days.
Delays, my lord, actually, my lord, is 31 days. However, my lord, at para number 3, there are some points I want to make an objection, my lord, because on the first perusal, my lord, I find that in para number 3, the judgment and award dated this such and such. This is 22/4/2025. Reached the empaneled lawyer on 1/5. So there is already a delay of 9 days.
Right, learned counsel for the petitioner Hooper is for adjournment on the ground of absence of learned counsel conducting the case. Learned counsel for the respondent submits that he would file objection to the instant application. Accordingly, leaves the matter after 2 weeks.
Obliged.
Part 2, item number 1.
May I please, Your Lordship, by this criminal appeal, the appellant is challenging the judgment and order dated 29/4/2025 and sentence order dated 30/4/2025 passed by the Court of Judge Special Court and the NPS Act, ISOL, by which the appellant was convicted and sentenced to undergo rigorous imprisonment for a period of 10 years, and also with a fine of ₹1 lakh. In default, rigorous imprisonment for another 10 months. The appellant was arrested in connection with excise case number 63 of 2017, dated 22/3/2017, under section 20B2C of the NDNPS Act. And the seized article in this case is 21.98 grams of ganja. Then the appellant was arrested on 21/3/2017 at 11:13 p.m. by S. Idal Biaktuanga, while he was intercepted one taxi bearing registration number MZ01L1562 boarded by the appellant James Tanglian Manga advised upon sought by ISOL, and the said taxi in 23 polythenes kept inside 2 bags were recovered. All were seized, weighed as 21.98 grams, and repackaged and sealed, and the appellant was arrested. Then, upon the submission of seizure report and arrest report, the instant case was registered against the appellant under section 20B2C of NDNPS Act 1985. That during the investigation, the seizing officer as well as seizure witness were examined. The appellant was also interrogated. Inventory was prepared by the investigating officer and was certified to be correct by the judicial magistrate first class. Then samples were drawn from the seized contrabands and photographs of the SA were taken. Samples of the SA were also sent to FSL Mizoram for examination, and its report revealed that samples are ganja. Complaint sheet was filed against the appellant upon prima facie case being found against him for possession of 21.98 kgs of ganja in violation of Section 8C of the Act, punishable under Section 20B2C of the Act. Then, charge under Section 20B2C of the Act was framed against the appellant on 24/10/2018. It was read over and explained to him, and he was asked if he pleaded guilty or not. The appellant pleaded not guilty and claimed the trial. During the trial, the prosecution examined 6 witnesses who were examined. Then the appellant was also examined under Section 313 CRPC. Then, after the trial was the examination of witnesses were conducted. Both parties filed written arguments, and that after the trial was completed, judgment was pronounced on 29/4/2025, whereby the appellant was convicted accordingly under Section 20B2C of the Act. The appellant was sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of rupees 1 lakh. In default of fine, to undergo rigorous imprisonment for another 10 months for committing offense punishable under Section 20B2C of the Act, and in violation of Section 8C of the Act, Vice Sentencing Order 30/4/2025. Then, may I please your Lordship, the first ground of my first ground of appeal in the instant appeal is that there is a violation of Section 50 of the NDNPS Act.
How?
May I kindly bring you to page number 13. Who is
But
a
he was carrying it in a bag.
Yes.
It's not on his person, inside his body.
Your Lordship, if I may, by looking at the petition submitted by the petitioner, by the appellant, the grounds which you have mentioned, there is no violation of Section 50 in his grounds, which you have written down in his petition.
Oh, you have not taken that ground in your appeal?
If Your Lordship, if I may take you to page number 5 of his appeal petition.
Yes, what is that?
Here, Your Lordship, the appellant counsel had mentioned 3 grounds.
You see, anyway, 50 will not be attracted because he was carrying it in
Exactly.
external bag. So 50 is anyway gone. That has been settled long ago by the Supreme Court.
But anyway, your Lordship, the body search was conducted on the appellant.
No, but the recovery was not made from the body. It was made from the bag. Okay, anyway, we have noted violation of Section 50, okay.
Yes, because PW number 1 stated that the excise personnel conducted search on my passenger, that is James Tanglian Manga. Then in his cross-examination also he stated that it is a fact that the excise personnel did not ask the accused whether he wanted to be searched in the presence of gazetted officer or magistrate in my hearing. So that is what he had stated. So my submission is that since he was not asked whether he wanted to be searched in the presence of gazetted officer or magistrate, there is a violation of Section 50.
Who admitted? Who stated in?
A taxi driver.
Huh?
A taxi driver who was a PW number 1. The appellant had hired a taxi. Then the driver of that taxi was produced as a prosecution witness number 1. Then he stated that
PW1?
Yes, PW1. In his examination in chief, he stated that the excise personnel conducted search on my passenger. Then in his cross-examination at Parantu, he also with regard to my point of submission, I would like to rely on State of Punjab versus Baldev Singh, reported in 1996.
Yes.
State of Punjab versus Baldev Singh, 1996, volume 6, SCC, page number 172. The operative portion is para 57 of the said judgment. And
Yes.
And my next ground of appeal is, Your Lordship, there is a doubt with regard to the samples drawn before the magistrate and the sample tested at the FSL. We cannot say the samples tested in the FSL cannot be said to be the samples drawn before the magistrate.
Why is that?
Because on page number 17 of the paper book, may I kindly bring you to page number 17 of the paper book?
Page 17 of paper book.
Yes. The position of PW number 1. In para PW number 4, who is the seizing officer, on para number 7, he stated that weighing of SA, sealing and packing of the SA was done at the PO in the presence of civilian witnesses. Then he also stated in his cross-examination that on para number 1, it is a fact that I have no search warrant in searching the accused airbag, and I did not seize the said airbag which was used for keeping the said SA. It is a fact that I do not know whether the accused airbag was returned to him or not. He stated in his cross-examination that I did not seize the said airbag which was used for keeping the said SA. Then he also do not know that whether the accused airbag, the airbag of the accused was returned to him or not. Then may I kindly bring you to page number 19. Parathi, he who is the senior civil judge before whom samples were drawn. On Parathi of the in the examination in chief, on the same day, SI Ring Nunga made an inventory of SA, and the details are as follows: name of NDPS ganja, quantity 21.98 kgs, mode of packing in black polythene and contained in 2 bags, marks and numbers 23 polythenes. So, since the airbags by which the appellant is carrying the alleged seized articles were not seized by him, but here it is contained in 2 bags. So there is a chance.
No, this is
in the
in
bags
black
by which-
polythene and contained in 2 bags.
Yes, there is a
But-
chance in the bags by which the seized articles were carried, but there is no certainty that the content of the 2 airbags were changed or not. It is not. There is a doubt with regard to the contents of the 2 airbags. While seizing the seized articles and while
Yes, the bags were not seized. The what was inside that was seized according to the prosecution.
Yes. What was inside the 2 airbags?
Yes,
was
the question is
seized.
whether at the time of seizure they were properly sealed or not.
Yes.
That is all, regardless of whether the bags were seized or not.
The bag was not seized.
No, not necessary. If the contents therein have been recovered and properly sealed and packed, then even if the bag is not seized, what
Yes,
is the
Your Lordship,
difficulty?
my submission is, but we don't know. The
FSL is not
trial
examining the bag, FSL is examining the product only.
But, my lord, the
You
seized
want to say that
articles-
the samples examined by the FSL are not
Yes,
the
yes,
same
yes.
as the ones drawn from the possession of the accused,
Yes.
is it not?
The samples were drawn before the magistrate. So, while they were seizing the seized articles, they are contained in 2 airbags. But the bags by which the seized articles were carried is not seized by the seizing officer. So there is a change in the bags by which the seized articles were carried. But it is not proof beyond reasonable doubt that the two bags by which the contents of the two bags while seizing the seized articles and while producing before the magistrate are the same or not. Because there is no go down receipt. It is seized on 21/7/2017, and the same was produced before the magistrate on 22/3/2017. So there is a gap of time, a time gap between. It is not clear whether the seized articles were kept in a safe custody on the night of 21/3/2017. There is no certainty that the contents.
What is date of seizure?
21/3/2017.
21/3/2017.
2017.
Then
the same was
produced before magistrate on
22/3/2017. And the samples were sent to the FSL on 23/3/2017. But the prosecution cannot produce an evidence to show that the seized articles and the samples drawn were kept in a safe custody during 21/3/2017 to 23/3/2017.
Yes.
And PW number 7 has also stated in page number 20 of the paper book the same thing on para number 6 of his examination in chief. On the same day I made an inventory of SA and the details are as follows. Name of NDPS Kansa, quantity 21.98 kgs. Mode of packing, packet in black polythene and contained in 2 bags. Marks and numbers 23 polythenes. So he stated in his cross-examination, para 4, that it is a fact that the accused was arrested on 21/3/2017 and the essay was produced before the magistrate on 22/3/2017. And between the period of 21/3/2017 to 22/3/2017, the essay were under the custody of the Excise Department. He simply stated that they were under the custody of the Excise Department. But there is no evidence, documentary evidence.
That is, you are reading PW?
This is PW number 7, who is the case IO. There is no go-down receipt or Malkhana receipt to show that they were kept in a safe custody. Then, may I please your lordship, on page number 26, it is the inventory of the narcotic drugs and psychotropic substances. Then,
yes.
And the list of samples drawn is on page number 27. 23 samples were drawn, but there is no mentioning of weight of the samples drawn. for the magistrate. As per the list of samples drawn, weight of the samples were not stated in the list of samples drawn. There are 23 samples, but weight of the samples were not stated in the list of samples drawn. Then the FSL report is on page number 36, where it is written that some are 9.32 grams, 11.7 grams, but it cannot be stated that they are the samples drawn before the magistrate, because there is nothing to compare with the list of samples with regard to the weight of the samples. We cannot confidently say that the samples tested in the FSL were not the samples drawn before the magistrate, because weight of the samples were not stated in the list of samples drawn. Therefore, this case is very doubtful. Then, moreover, as per on perusal of the paper book, forwarding letter to the FSL is also not available or not exhibited by the prosecution witnesses. There is no forwarding letter. Therefore, then further, PW number 6, the FSL expert who is Lal Monoma, Assistant Director, FSL Aizawl, as per page number 34, who is among the list of the witness, is also not produced before the court to establish the case of the
Who
prosecution.
proved the FSL report?
Yes, to prove that, yes. In respect
FSL
of-
report was proved by whom?
Please tell us.
FSL report?
Yes.
The FSL expert was examined or not?
Not examined.
So who proved the report, exhibited the report? IO?
IO. Yes, he stated that Exhibit 9 and Exhibit 9A are FSL report. The case IO, PW number 7. In order to support my submission, I would like to submit two judgments. One is by this Gauhati High Court and by the Apex Court. I'd like to submit Mohammed Khalid and another versus State of Telangana, 2024, Volume 5, SCC, page number 393. On page number para 23 of the said judgment. May I kindly read out my lord. On para 23 of the said judgment. Contrary to the evidence of PW1, PW5 stated that 3 samples of ganja were taken out by Sub-Inspector LW10 and were handed over to the witness who forwarded the same to the SCP for sending it to FSL. In cross-examination, the witness admitted that he did not file any document to show that the property was kept in Malkhana. The Malkhana register was not produced in the court. The FSL report, Exhibit P11, does not disclose about the punch sheets and seals and signature of accused on samples. The property deposited in the court, Madamal was not having any official seal. The witness also admitted that he did not take any permission from the court for changing the original 3 packets of Madamal ganja to 7 new bags for safekeeping. These glaring loopholes in the prosecution case give rise to an inescapable inference that the prosecution has miserably failed to prove the required link evidence to satisfy the court regarding the safe custody of the sample packets from the time of seizure till the same reached the FSL. Then on page number 29, as a consequence of the above discussion, we are of the firm opinion that the prosecution has miserably failed to prove the charges against the accused. The evidence of the police witness is full of contradictions and is thoroughly unconvincing. The conviction of the appellant accused, as recorded by the trial court and affirmed by the High Court, is illegal on the face of report and suffers from highest degree of perversity. And may I be allowed to submit one more judgment? In the case of Lalpek Louis versus State of Mizoram, GLT, it is 2022, volume 3, GLT page number 787. May I read out from page para 20. From the above evidence adduced, it is an undisputed fact that 15 hong of suspected heroin equivalent to 213.6 grams kept in 15 soap cases were recovered from the possession of the appellant on 23/6/2017. The appellant, along with the SA, was produced before the officer in charge, Champa Excise and Narcotics Substation, by the seizing officers for further necessary action. On 24/6/2017, as the case IO in front of the magistrate prepared inventory of the seized suspected heroin and draw samples from the main body of the for chemical analysis, which she sent to Forensic Science Laboratory Aizawl. On cross-examination, she had clearly stated that she drew 2 packs each as sample from one soap case to suspected heroin, and in total, the 3 samples were taken, 30 numbers. The weight of each sample was about 50 milligrams. However, it is seen that the FSL report on 18/8/2017 states that 6 of the exhibits were of purity 85%, and the rest of the 9 exhibits were also found to be heroin of purity 83%. I find that there is no explanation as to why only 15 numbers of samples was received when 30 numbers of samples said to be sent for chemical analysis. Well, the case IO had stated that weight of each sample sent to was about 50 grams. However, in the report, no number such and such dated 8 August 2017. Exhibit as B3. It is seen that the weight of the 15 numbers of parcels polythene packets range from 16 mg to 34 milligram, which are packed and enclosed in the paper envelope sealed with wax seals. This is a considerable difference from the said weight of the same sample, that is 50 milligrams. Again, there is discrepancy in the inventory made before the magistrate, which shows that quantity of samples was 20 milligrams each. I am of the considered view that the discrepancies in the number of samples and the weight of samples sent to the FSL and those received by the Forensic Science Laboratory on 10/7/2017 cannot be overlooked. The court also finds that it is about 2 weeks for the sample of the seized article to reach the Forensic Science Laboratory, which was packed on 24/6/2017 and received by the Directorate of Forensic Science Laboratory, Aizawl, on 10/7/2017. Exhibit 3 mentions that memo number such and such dated 3/3/17 was received by the office on 10/7/17. There is no explanation as to where the seized sample was kept during this period, 24/6/2017 to 3/3/2017. Well, the deposition of the cash IO mentions that on 24/6/2017, in front of the magistrate, she prepared inventory of the seized suspected heroin and draw samples, which was sent to Forensic Science Laboratory. Then, and on para 22, in the instant case, in view of the aforesaid discussion and the decided cases in this court, I am the considered view that the appellant may be given the benefit of doubt, and as such, the judgment and order dated 18/2/2019 passed by the Special Court and convicting the appellant under Section 21B and DNBS of 85 is set aside and the appellant is acquitted of the charge
Yes.
under. Yes. Here also, I pray that the appellant shall be given the benefit of doubt. Another ground of my appeal is that with regard to the time of arrest or apprehension, there is a doubt which cannot be explained by the prosecution because PW number 1 on page number 13, he stated that the incident happened in his cross-examination. It is a fact that I cannot recollect the exact time of the seizure of the SA and arrest of the accused. And as far as my memory is concerned, it would be 9 to 10 p.m. It would be 9 to 10 p.m. PW number 2 on page number 15. She stated in her cross-examination, para number 5. Para number
PW?
5, number 2.
Yes.
Para number 5 of her cross-examination. It is a fact that before I reached the PO, the excise personnel had already checked the bag, as I was told by the seizure witnesses, namely Bilal Chanboy, and the incidents took place at around 11 p.m. And PW number 3, Lal Chanboy, on page number 16, on page number 5. She does not mention about the exact time, but she stated that it is a fact that excise personnel had already checked the bag before they brought the accused inside my residence. It is a fact that excise personnel had already opened and checked the bag before one of witnesses, Miss Janet Chung, reached the PO. Then, while the seizing officer stated...
Now, what did you read just now?
Page number 16 of the paper book, para 5 and 6 of the cross-examination of PW number 3.
Yes.
Yes, may I please, on page number 17. On para number 5 of the examination in chief of the seizing officer. On 21/3/2017, before noon, we detected the suspected person at 5 upon Zhou Huirang Mall Road with his hired taxi bearing number MZ01L1562. We halted the cited taxi and detained each passenger. He had detected and detained him before noon on 21/3/2017. But the driver of that taxi, PW number 1, stated in his examination in chief that I know the accused person who is present in the court today. I earn my living by driving taxi. At the time of incidents in this case, I was driving taxi bearing registration number MZ01L1562 on the night of 21/3/2017. While I was on servicing my taxi, one person named James Tanglian Manga had boarded in my taxi. When reaching Vaibagon Zhou Hui, when the passenger accused James Tanglian Manga was about to get down from my taxi, excise personnel stopped us for convenience. The excise personnel took the accused inside the nearby residence. I was also taken inside the residence. Then the excise personnel conducted search on my passenger, that is James Tanglian Manga. As per the deposition of PW number 1, the incident happened on the night of 21/3/2017. But the seizing officer, PW number 4, stated in his examination that before noon on 21/3/17, they had already detected a taxi and he was already detained at the daytime. So, but PW1 stated the the appellant stopped him on the night only. So there is a clear contradiction between the statements of PW1 and PW number 2. Because therefore, since the case of the prosecution is full of doubts, then you cannot be said that the case of the prosecution is proof beyond a reasonable doubt, and that doubt shall be given to the benefits of doubt shall be given to the appellant. Then one more submission is there is the appellant was not furnished with a copy of ground of his arrest or arrest intimation in writing. Then there is a violation of his fundamental right enshrined under the Article 22 of the Constitution of India. The paper book does not show that, or the deposition of the prosecution witnesses, the seizing officer and the IO does not show that, or there is no material available in the paper book that the ground of his arrest or arrest intimation in writing was given, was furnished to him. In respect of this,
Those does not apply after conviction.
yes. But my lord, my submission is that the
Now you have the whole judgment, not just grounds of arrest. Yes.
Yes. Then one last point is violation of standing order 1 of 1989. Order 2.3. May I allow to submit a copy of that standing order.
Violation of which part?
Page number 4, order 2.3. Page number 4 of that paper. Yes, order 2.3. The quantity to be drawn in each sample for chemical test shall not be less than 5 grams in respect of all narcotic drugs and psychotropic substances, save in the case of opium, ganja, and charas, where a quantity of 24 grams in each case is required for chemical test. The same quantity shall be taken for the duplicate sample also. The seized drugs in the package container shall be well mixed to make it homogeneous, and representation treated before the sample in the duplicate is done. On perusal of the FSL report, all the weights of all the samples were much below 24 grams. Then the duplicate was also not drawn before the magistrate, and there is a violation of standing order 1 of 1989. That's all my submissions, Your Lordship. Then may I pray that the conviction and sentence order of the appellant may be set aside in court, and by giving the benefit of doubt to the appellant.
Yes.
Yes, Your Lordship. May it please Your Lordship. Your Lordship, what I have to mention is that in the present appeal, criminal appeal is wholly without merit. The learned trial court had rightly convicted the appellant under Section 20B, Section 20, Subclause B, Subclause 2, Subclause C of Indian PS Act, based on clear and consistent evidence. Your Lordship, in the present case, the ganja was recovered from the 2 airbags carried by the appellant, and which established his exclusive and conscious possession that he has carried that contraband substance. And Your Lordship, once the statutory provision, once the conscious possession is proof, the statutory presumption under Section 35 and 54 of NDNPS Act applies, in which the appellant fails to discharge himself even during his examination under Section 313 CRPC. Your Lordship, if I may take you to the examination of appellant under Section 313. That is in page number 3. Page number 3 of the paper book.
Page
3, number 3.
of paper book.
Yes, Your Lordship. Here in this question number 1, Your Lordship, if I may read out. The evidence against you is that on 21/3/2017 at 11:13 p.m. you were arrested for illegal possession of 21.98 kgs of ganja by Bakondong Hoi Aizong, Mizoram. Is that true? And he admitted that yes, it is true. So, Your Lordship, during his examination, he admitted that he had possessed the contraband ganja, and he was seized due to possession of that ganja. And the only explanation that the appellant has given, that points we can see in question number 4, Your Lordship. The evidence against you is that you admitted before the investigating officer that you purchased the SA from Darkhai, Myanmar, and tried to resell at Rangamwal for monetary gains. Is it true? And he said that no, it is not true. I was called to come down. The one who had called me was not arrested, but I was. So
What is this stated in Mizo?
What he meant to say is that the actual owner was not arrested, but he admitted that he possessed. He admitted that he possessed the ganja, and what he meant to say is that because the actual owner was not there, the actual owner was requested him to carry that. And in another point, Your Lordship, where it is making clear is that question number 7. Do you have any explanation in respect of your case? I was deceived. I was called to come down because they wanted me to be imprisoned in their place. So, Your Lordship, he knows that he is carrying ganja.
No, what is the meaning of this? Do you have any explanation? What is his answer?
He said, I was deceived.
I was deceived.
Yes. I was called to come down because they wanted me to be imprisoned in their place. So he knows that he is carrying the contraband articles. And moreover, Your Lordship, if we have to look into this 313 examination, he did not mention the name of the owner. He never mentioned that. He never gave any explanation regarding that there is the actual owner. This is his mere explanation that stating that he has no ownership. He doesn't claim that he has no conscious possession. The only things he claims is that he has no ownership. But Your Lordship, conscious possession is the relevant portion in NDNPS Act. And once the conscious possession is proved, conviction can be based on that conscious possession. And regarding that conscious possession, I have one citation. (2025) SCC Online SC 122 Rakesh Kumar Raghuvanshi versus State of Madhya Pradesh. Para number 21, Your Lordship. paragraph number 21. If I may read out. Conscious possession refers to a scenario where an individual not only physically possesses a narcotic drug or psychotropic substance, but is also aware of its presence and nature. In other words, it requires both physical control and mental awareness. This concept has evolved primarily through judicial interpretation, since the term conscious possession is not explicitly defined in the NDPS Act. This court, through various of each decision, has repeatedly underscored that possession under the NDPS Act should not only be physically but also conscious. Conscious possession implies that the person knew that he had the illicit drug or psychotropic substance in his control and had the intent or knowledge of its illegal nature. So, Your Lordship, with regard to this citation, it is true that he has conscious possession, and he claims that the owner, what he claims, the owner had deceived him to be imprisoned in his place. So that means he knows that he is carrying that contraband ganja, and conscious possession is proved by the prosecution. And my another point is that regarding that section 50, recovery was made from the airbag of the appellant carried by him. So, Your Lordship, where there is no recovery from the persons, section 50 of NDNPS cannot be attracted.
Yes.
And regarding that, I have one citation. Two 2011-3 SCC 521. Here there are 3 cases compiled, Your Lordship. Para number 19. If I may read out.
Yes.
The scope and ambit of Section 50 was also examined by this court in the state of Himachal Pradesh versus Pavan Kumar in SCC Paras 10 and 11. The court observed as follows. We are not concerned here with the wide definition of the word person, which in the legal world includes corporation, association, or body of individuals, especially in this type of cases. Search of their premises can be done and not of their person. Having regard to the scheme of the Act and the context in which it has been used in the section is naturally means a human being or a living individual unit and not an artificial person. The word has to be understood in a broad common sense manner and therefore not a naked or nude body of a human being, but the manner in which a normal human being will move about in a civilized society. Therefore, the most appropriate meaning of the word person appears to be the body of a human being as presented to public view, usually with its appropriate coverings and clothing. In a civilized society, appropriate coverings and clothing are considered absolutely essential, and no sane human beings comes in the gaze of others without appropriate coverings and clothing. The appropriate coverings, Your Lordship, I will jump to sub-para 11, the second paragraph. A bag, briefcase, or any such article or container, etc. can under no circumstances be treated as body of a human being. They are given a separate name and are identifiable as such. They cannot even remotely be treated to be part of the body of a human being. So, Your Lordship, it is very clear that when the recovery was made from the back. It cannot come under section 50 NDPS. And Your Lordship, regarding the submission made by the council regarding the violation of standing order and section 52A of NDPS Act. Your Lordship, with regard to that, what I would like to submit is that merely non-compliance of certain provisions under the standing order and section 52 does not vitiate the trial automatically, where the foundational fact is proved beyond reasonable doubt. And in that regard, Your Lordship, I would like to submit another citation. (2025) SCC online SC 110 Dharat Ambali, para number 50. If I may read out, Your Lordship. We summarize our final conclusion as under, although section 52A is primarily for the disposal and destruction of seized contraband in a safe manner, yet it extends beyond the immediate context of drugs disposal, as it serves a broader purpose of also introducing procedural safeguards in the treatment of narcotic substance after seizure, in as much as it provides for the preparation of inventories, taking of photographs of the seized substances and drawing samples therefrom. In the presence and with the certification of a magistrate, mere drawing of samples in presence of a gazette officer would not constitute sufficient compliance of the mandate under section 52, subsection 2 of the NDPS Act. And in sub number 2, although there is no mandate that the drawing of samples from the seized substance must take place at the time of seizure as held in Mohan Lal Supra, yet we are of the opinion that the process of inventorying, photographing, and drawing samples of the seized substance shall, as far as possible, take place in the presence of the accused, though the same may not be done at the very spot of seizure. Here, Your Lordship, what I would like to mention is that at the time of inventory, the accused was present there. The accused was there. His presence is there. And in subclause number 3, any inventory, photographs, or samples of seized substance prepared in substantial compliance of the procedure prescribed under section 52 of the NDPS Act and the rules standing order thereunder would have to be mandatorily treated as primary evidence as per section 52A, subsection 4 of the NDPS Act, irrespective of whether the substance is original, is actually produced before the court or not. So, Your Lordship, at the time of trial, at the time when the case IO has exhibited the following documents, the inventory, the expert opinion, the expert report, sorry. So there is no dispute. It was exhibited and already treated as primary evidence. So, Your Lordship, the appellant cannot challenge that at this later stage because it is already accepted, and during post-examination also no question has been raised regarding the purity of the
samples.
Kansa. Yes, Your Lordship. And coming down to sub number 4, the procedure prescribed by the standing order rules in terms of section 52A of the NDPS Act is only intended to guide the officer and to see that a fair procedure is adopted by the officer in charge of the investigation, and as such, what is required is substantial compliance of the procedure laid therein. Mere non-compliance of the procedure under section 52A or the standing order rules thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence rendering the prosecution's case doubtful, which may not have been there had such compliance been done. Should take a holistic and cumulative view of the discrepancies, that may exist in the evidence adduced by the prosecution and appreciate the same more carefully, keeping in mind the procedural lapses. If the other material on report adduced by the prosecution, oral or documentary, inspired confidence and satisfies the court as regard the recovery as well as conscious possession of the contraband from the accused person, then even in such cases, the courts can without hesitation proceed to hold the accused guilty, notwithstanding any procedural defect in terms of Section 52 of the NDPSA. And Your Lordship, another point regarding that non-examination of the chemical expert. Your Lordship, if I may take you to Section 393 of CRPC. Reports of certain government scientific experts. Any documents purporting to be a report under the hand of a government scientific expert to whom this section applies upon any matter or things duly submitted to him for examination or analysis and report in the course of any proceeding under this code may be used as evidence in any inquiry, trial, or other proceeding under this code. So, Your Lordship, the report can be accepted as primary evidence. And here there is one condition that when there is a complaint against the report and where there is doubtfulness, and in that time the appellant has to seek to call the expert opinion. But during the trial, Your Lordship, there is no complaint regarding the report. It was accepted and there was no disputed. So the need of examining the scientific expert does not arise. His report is there and exhibited. So, Your Lordship, how I would like to conclude my submission is that the conscious possession is proved, and regarding the minor discrepancies on the date and time, not the date, the time of the seizure and arrest, that must be overlooked, Your Lordship, since the core issue that the contraband ganja was seized from the conscious possession of the appellant is proved beyond reasonable doubt by the prosecution. So the conviction and sentence of the learned special judge is proportionate to the crime committed by the accused, and my submission and prayer is to uphold the conviction. Your Lordship.
All right. See you. CAV.
Oblige, Your Lords.